56 years on, there is no final word yet on the question if Aligarh Muslim University is a minority institution or not. But in a landmark decision, the 4:3 judgment led by Chief Justice of India, Chandrachud, has ruled that one of India's premier universities, Aligarh Muslim University, is entitled to minority status under Article 30 of the Indian Constitution, overturning the ruling in 1960s that stated that Aligarh Muslim University is not a minority institution. So it's a reversal that has happened. But a fresh bench judge or a fresh bench under the new CJI will be constituted to look at the minority institution claim further. But there is also another important aspect in the judgment, the way Article 30 has been interpreted. Chief Justice D.Y. Chandrachud, however, stated that the right granted by Article 30 is not absolute. And thus, regulation of minority institutions is protected under 19(6), which is about reasonable restrictions on rights of citizens. The court stated it is not necessary to prove that administration rests with minority to prove that the institution is to be a minority institution. Let me just break this down in very simple terms. Loosely translated, this means the minority institution may be established by minorities but doesn't have to be administered by minorities alone. This is a hugely significant part of the judgment as well and opens up the interpretation of Article 30 of the Indian Constitution to a much broader spectrum. The bearings of this judgment are huge, and our attempt tonight is to focus on the larger contours of this issue from two very different perspectives, two opposite perspectives, in fact. On my panel tonight are going to be Faizan Mustafa, author and educationist, as well as Hindol Sengupta, who's author as well as historian. Thank you very much. Good evening to both of you. These are interviews that we recorded a while earlier, but let's just straight go at this point to Mr. Faizan Mustafa, who's an author as well as an educationist. Thank you very much, Mr. Faizan Mustafa, for joining us. My first question, Mr. Faizan Mustafa, is how do you look at what's happened in the Supreme Court today? 56 years on, we are yet to decide whether Aligarh Muslim University is a minority institution or not. But nonetheless, let's just start from the place. Where do you look at what's happened in the court?
One, Sneha, after all, judges interpret laws, and judges are human beings. And human beings differ. You can see even today it is a 4-3 judgment. So we are interpreting man-made law, and accordingly we look at laws differently. So I'm not surprised if a 56-year-old precedent is overruled, because no bench in last 56 years has examined the correctness of the 68 judgment. So basically, it was for the first time that a 7-judge bench was looking at the correctness of its own judgment. And overruling is routine. You see, Golaknath judgment was overruled in Keshavanand Bharati to give us the basic structure theory. Gopalan judgment was overruled in Menaka Gandhi after 28 years. Gopalan had said that, if there is a law which takes away your personal liberties, that is good enough. But Menaka Gandhi said, no, that law must be just, fair, and reasonable, and non-arbitrary. So in a modern legal system, such things do happen. You just saw that how the abortion judgment in United States has recently been overruled. So that is not a news. The big news is that Supreme Court is interpreting Article 30 in a certain way, of course, largely relying on its own earlier judgments, because Aziz Basha itself was an exception in the otherwise very liberal line of judgments of the Supreme Court. That is why it was criticized as productive of great public mischief. India's greatest constitutional law expert, H.M. Sirvai, who was the Advocate Journal of Maharashtra for 18 years, he had said it that this is productive of great public mischief and must be overruled. And it has now been overruled. The whole problem of the 68 judgment was that it completely ignored the effort made by the Muslim community prior to the enactment of 1920 Act. So they had set up a college, they raised funds, they gifted properties. They did not have the power to pass a law. Law is to be passed by the government. So they invoked the sovereign power to pass a law. Now, looking at that law as a point of relevance, that whatever happened prior to 1920, not relevant. We will just look at 1920. This is what Supreme Court has overruled today. And it said that word establish means to found, and we must look at the genesis, how the idea originated. If that person was from a minority community, if he wanted to set up an institution primarily for his community, how he raised funds, what kind of speeches he gave, what correspondence happened between the government and the promoters, and then look at all the provisions of the act. So what Chief Justice Chandrachud was saying, take a holistic view of the thing to decide whether an institution was established by a minority or not.
You know, that's interesting, and it's also, how would you look at how the Supreme Court has gone ahead and interpreted Article 30? Because the Supreme Court has gone ahead to say that minority institutions may be established by minorities, but not necessarily administered by minorities alone. How do you look at that?
So this is a very important observation. In fact, on the administration, that the minority need not exclusively administer their institution. What Chandrachud has done is absolutely a new ground for Article 30. Generally, the law was settled on this, and it has been reiterated today that if you have established an institution, then you get a right to administer it. Now, in Basha, they said that you neither established Aligarh nor you have been administering. And why you have not been administering? Because any decision by university authorities can be struck down by the Lord Rector, the Governor General. Now, the university's stand was that this provision was there even when we were a college. And this was a provision which we have ourselves included in our college. It is just a transition to university. What the provision says, if a university takes a decision against the act or against the statutes and ordinances, then it will be struck down. So basically, it is a provision to ensure that there is no maladministration. Now, what Chief Justice Chandrachud today held, that minorities may not have specialists to entirely administer their educational institutions. For instance, if I am setting up a medical college and I am a law professor, then all the people I need to keep on governing body cannot be Muslims, and therefore I will take neurosurgeon, I will take cardiosurgeon from other communities. It's better that minorities in their administration involve other communities, so that the institution become an institution of excellence. The whole idea is that these institutions should not become, ordinary institutions. So in terms of students, they cannot be exclusive, that they will say, we will educate only minority. They will not give only religious education. And in terms of administration also, minorities are entitled to take the help of the other communities, as in raising of funds. Even others can also gift lands. So basically, the whole project is that it is a right of a minority to administer. They may exercise this right exclusively on their own, or they may invite experts and keep people in their governance who are not members of the minority community.
Right. Last question, sir. I mean, for ordinary people, ordinary citizens who may not be very closely following how minority institutions function, even within this group, there's a huge lot of difference. For example, of course, AMU, Aligarh Muslim University, is still, there's a huge tussle around whether it is a minority institution or not. That has to be settled. But let's look at some others, like, for example, St. Stephen's, or you have Christ University. Both are minority institutions, but very different in the way they function. St. Stephen's, for that matter, is under Delhi University as well, even though being a minority institution. So, I mean, the larger spectrum of how to look at the discourse around minority institutions, how do you look at that?
One, acknowledgement of a fact that a minority established it. Continuity with that history. And then you will see on their governing body, there is a Christian presence. On the governing body of Aligarh, there is a Muslim presence. And then there is more to it. If you are an ordinary institution, then you cannot have any reservation on the basis of religion or language. You will be hit by Article 15. If you are a minority institution, you can be a Hindu minority institution. I have a number of times written, Sneha, on this, that Hindus are religious minority in India, in some union territories and states where they are less than 50%. Number of northeastern states, in union territory of Kashmir, in Punjab, for instance, in Lakshadweep, and they can be linguistic minority in all other states. So if a Tamil Brahmin in UP wants to set up a Tamil medium institution for the Tamilians living in UP, even though he is a Hindu, it will be a minority institution. Therefore, to understand minority institution only from the lens of religious minorities is absolutely wrong reading of Article 30, which says minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. Now, if you are a religious minority, the institution is established for you. Now our constitution says, then in that institution, you can reserve seats for Christians or for Muslims or for Tamilians or for Hindi medium. Or in Delhi, you have number of colleges which are Sindhi minority institutions, where you can reserve seats for Sindhi speaking people. Otherwise, it will be hit by Article 29. So that is another benefit, that in a minority institution, you will not apply SC, ST, OBC reservation, but you can have a minority reservation, whether in the name of religion or in the name of language, depending upon which is a minority which has set up. And why this is so? There is a logic to it. If you have SC, ST, OBC reservation, 50% seats are gone. Now, again, if you say you will have 50% reservation for the minority, it will become 100% reservation. 100% reservation is not permissible. Therefore, in minority institutions, they can reserve seats generally for 50% for their minority, and 50% seats will be available for general candidates. I have been writing and saying this for ages, that minority institutions do a great national service because 50% of their students come from majority community. Look at St. Stephen's also. 50% are non-minorities. In fact, that number may be much more.
Right. Faizan Mustafa, of course, there may be, a very different perspective to this as well. But thank you very much for your time. It's, of course, a very important judgment, though it's ironical that the final verdict of this is still awaited on what the status of Aligarh Muslim University is. But nonetheless, huge ramifications for what the court has said and interpreted as well. Faizan Mustafa, thank you very much for joining us.